My background is principally in the criminal courts, but I've had extensive experience in civil matters. In my opinion, appeals across the board, whether they be criminal or civil appeals or appeals against disqualifications or other findings, are governed by two principal approaches, and these are approaches I've always undertaken in regards to my wide and extensive practice in the Court of Appeal or otherwise, and I've represented people in some very high profile matters successfully in the Court of Appeal. The approach is twofold. The first approach is that there has to be proper preparation of an appeal. What do I mean by that? Well, what that means is that someone comes to see me as a result of themselves or a friend or a family member who has got into difficulty and feels that the first instance judgment, whatever form that may be, is something which needs to be reviewed. What do? I look at, first of all, very clearly I examine the case papers. That is the most important thing, because two things often emerge during the currency of that. The first is that a pair of fresh eyes can uncover things which perhaps the original team did not uncover. It's not their fault, but it's something which a pair of fresh eyes can often do. Second, it can often lead to a different approach to the whole appeal. Once I've examined the case papers on that basis and consider whether there are at least arguable grounds, it's then very much my function to meet those who are involved in it, to ensure that I've understood the position correctly, I've got the full picture, and once I've got the full picture, I'm then in a position to fully advise them as to whether there are realistic prospects of appeal. It won't assist anyone to give advice which is going to be a losing appeal, because that is simply costly, it builds up false hopes and it doesn't assist. But it is also right that often where there are matters which have the look of a hopeless appeal, there's sometimes something which has not been properly grasped, and it's my job in those circumstances to examine that particular aspect and to say, yes, we have this prospect. My job then is to give realistic advice in a context so that everyone going forward knows the circumstances. Once that preparation has been fully undertaken, and that's my job to ensure that it is, and it will be, it's then my job particularly and uniquely to present the case to whatever appeal forum I'm involved with, and that involves a number of different features. It involves, first of all, being realistic in terms of my approach. It involves focusing on the principal issue. Appeals are very different to any other first instance hearings because they are a review of the matter, and so you must ensure that you always have focus, and as a result of that, if you have focus, the appeal will be more attractively pursued. Once you've then focused and you have ensured that you are putting all the proper grounds, it is important then, as I say, to be realistic but also firm in your approach. And in those circumstances, sometimes appeals which do not immediately attract the sympathy of the tribunal, they can be persuaded by virtue of you producing matters which will either not produce them in the first instance, or, more importantly, putting a different interpretation upon existing features. And so my job, as I say, when examining any application to appeal, any circumstances of potential appeal, whether it be for conviction, against sentence, or against any, or in any other format, is to ensure those two stages are formally produced, such as preparation, presentation.